Good evening to you all. My name is Christoph Paulussen, and I would like to welcome you to the Instituut and to the Supranational or SCL lecture. And a particular warm welcome to the students of Washington College of Law who are following a month-long training program here in this very room on international criminal law and the legal aspects of countering terrorism. Now, the SCL lecture series is a series on international criminal law and has been organized since 2003 by the Instituut in cooperation with the Coalition for the ICC and the Grotius Center for International Legal Studies of Leiden University. And we're very happy to have with us tonight Professor Michael Scharf and Professor Milena Sterio, with whom we will have a conversation on the legacy of the ad hoc tribunals. And Professor Michael Scharf is Dean of the School of Law of Case Western Reserve University School of Law, and Professor Milena Sterio is Associate Dean for Academic Enrichment at the Cleveland Marshall College of Law. And they've assisted several international tribunals and have written extensively on international trials, including a new book, and I have here, The Legacy of the Ad hoc Tribunals, published this spring. And as such, of course, they are the ultimate experts for tonight's event. So thank you so much for being with us tonight. Now, for those of you who have followed the SCL lecture series, the format is a little bit different, so I will start asking a few questions to our guests, after which I will open the floor for a general Q&A with you, the audience. So I didn't even mention this in the beginning, but the two of you are directors of the Public International Law and Policy Group, which is a Nobel Peace Prize nominated NGO. And in December, your NGO released a report concluding that Burma's treatment of the Rohingya people constituted genocide. Now, what have the trials at the ad hoc tribunals revealed about the causes and nature of this international crime, which is also often called the crime of all crimes? Michael, you would like to start?
Sure. So, we have with us in the lecture hall Alphonse Ori, and in my very first experience with the Yugoslavia Tribunal was the very first case, the Tadic case, in which Alphonse was a defense counsel, and he later, of course, became a judge at the Yugoslavia Tribunal as well as a Supreme Court judge in the Netherlands. And he probably will remember very vividly the same thing I do, which is a moment in the Tadic case when Judge Gabriel Kirk MacDonald, who was the presiding judge, she's an African-American judge from the United States, and she asked a UN witness, Judge Grev, who had interviewed something like 1,500 survivors of sexual crimes at the Karaterm and Ternopili prison camps in the Prijedor region of Bosnia. And the question she was asked by the judge is, how is it that these people that lived in Bosnia, who had the highest rate of interfaith marriage of anywhere other than in the United States, who had a history of getting along with each other that went back, several hundred of years, although sometimes the Serbs would still talk about the Battle of Kosovo Kyle. I mean, they really were in Bosnia getting along quite well. How was it that this could turn into genocide? How could people become so vehemently excited about the bloodlust of killing their neighbors? And this was a question that I have always wondered. How does a very civilized country like Germany in World War II, in Bosnia in the 1990s, go from being civilized to barbarism, to the worst of the worst crimes? And so Judge Grev looked at Judge MacDonald, and I could see her mind thinking, how is it that I can explain to this judge from the United States who has been through the civil rights movement in a way that she'll understand? And so what she said was this: Judge MacDonald, Your Honor, she said, picture what would happen in your country, the United States, if the KKK took over the United States government, and if they controlled all of the media, and if they beamed to the ordinary people 24 hours a day, 7 days a week, this vehemently racist propaganda. And the message was, they're coming to kill us, so we have to strike first. And then add to it that the government armed all the ordinary people with guns, and the ordinary people are like, why do I need guns? Because they're coming to kill you. And then the government says, now let's go get them. And that was the story of how genocide occurred in Bosnia. And then you think, well, could it happen in your own country? And I think that Thomas Hobbes was right. There is a thin line between civilization and barbarism. And in any population, there are good people and there are bad people. But what keeps everybody on the right side of that line is the law, it's the free media, and it is the checks and balances that most countries have. And when you don't have that anymore, you cross that line. And it's ever so easy to cross, and we always have to be vigilant about protecting those safeguards. And I think that's the story of the Yugoslavia Tribunal, and it's the story of the other tribunals, and it's the story of people who want to understand how genocide can occur.
Sure, so just very briefly. Just very briefly, I think what the ad hoc tribunals have taught us about genocide is that although there isn't a formal hierarchy of crimes in international criminal law, there isn't a document that says, genocide is a 1 and crimes against humanity is a 2 and war crimes is a 3, nothing like that. But I do think that the label genocide matters. And I think that might explain in some instances why prosecutors might charge cases with genocidal offenses. In instances where there isn't this label, victims, those affected by the crimes, might somehow feel harmed by the fact that their crime somehow got labeled something less than what they actually were. So I think the label matters, and I think also the prosecutions in the ad hoc tribunals have shown that it is really difficult to convict someone of genocide because of the special intent requirement, because of the evidence needed to obtain such a conviction. And so, I think the experience of the ad hoc tribunals has shown that while it is important to charge, defendants with genocidal offenses, that prosecutors also need to be carefully select cases because it is very difficult to obtain such convictions.
I want to add one thing, because you started off by asking about the work of our NGO with respect to the Rohingya in Burma. And we actually got a grant and were commissioned by the U.S. State Department to do a study where we interviewed 1,100 survivors of the Burma atrocities that had crossed the border into Bangladesh and were living in giant refugee camps. And when we interviewed all these people, we documented what they said, and we gave this to the State Department. And the State Department was going to publish our findings, including our legal conclusions. But then they decided, and this is relevant to what Milena was saying, let's just publish the factual findings and not talk about the legal conclusions. And the reason is because when a country finds that there is genocide and publicly says that, it creates tremendous public pressure to do something. And the United States was not ready to do anything for the Burma genocide, as it wasn't ready at first in Bosnia, and certainly not in Rwanda. This is a pattern you see over and over again. Genocide is a very strongly charged word. It has a lot of political power, and the government often doesn't want to use it. Now, what's really interesting is, and this is the first time I'm telling this, you're videotaping this, right? So I'll probably get me in trouble, but
we can cut it out.
It's all right. No, it's all right. So in the State Department, there was a big debate. There were people, especially at the lower levels, that wanted to put the statement that the NGO, the Public International Law and Policy Group, experts had found, based on the 1,100 testimonies, that it was genocide. And the higher-ups didn't want to. And so eventually somebody gave us permission to announce it on our own, separated from the State Department. We did it at the National Press Club, and it got tremendous world coverage. If you Google it, you'll see over 1,000 media reports of this. 11 days later, the U.S. Congress passed a non-binding resolution that said, we recognize that it's genocide, the U.S. should do something about it. Now, the U.S. has not done anything about it, but that was a positive step.
Now, your new book is about legacy. So what do you consider to be, let's say, the most important contributions of the international tribunals?
Sure. So I think that the Yugoslavia and the Rwanda tribunals really rebooted the field of international criminal justice, we had the Nuremberg Tribunals and then this long pause, and then in the early 90s with the creation of the ICTY and the ICTR, we really had a reboot, relaunch of this field of international criminal law, the idea of imposing international criminal responsibility to heads of state, military leaders, those responsible for the atrocities committed. So I think that's, very, very significant contribution in a general sense. I also think that the tribunals left a very, very important legacy of operational issues, case management, rules of procedure that I think the future tribunals will hopefully be able to build upon. And I think also the ICTY and the ICTR created and left a very significant legacy when it comes to the prosecution of crimes of sexual violence, which in the past had not been prosecuted, but now were prosecuted and hopefully will be prosecuted in the future.
The other legacy is that you probably all know the famous quote by Adolf Hitler in 1939 on the eve of his attacks on Poland, when he was asking the German military to do all kinds of atrocities that they were not comfortable doing. And he said, hey, don't worry about it, quote, "Who, after all, today remembers the fate of the Armenians?" And what he was saying is, look, we'll do this and nobody's going to care. Nobody punishes the perpetrators. There's never accountability. We'll be victorious, and this is what it takes. And it was part of the reason of the Nuremberg trials to make sure that history did not forget the fate of the Jews and the others that were killed by Nazi Germany. And ironically, there have been some opinion polls that show that there are a growing number of people today of college age that have never heard of the Holocaust. So the forgetfulness is starting to seep in, despite Nuremberg. But I think it would have been much easier to forget and to deny that had there not been the Nuremberg trials. Well, because of the Yugoslavia Tribunal, nobody is going to forget the fate of the Bosnians. And because of the Rwanda Tribunal, nobody is going to forget the fate of the Tutsis, especially. And the Permanent International Criminal Court is starting to make the same kind of inroads, where case by case they are creating a historic record by which it'll be much harder for the forces of revisionism and denial to ignore that these atrocities occurred. And that's the first step in deterrence. I do want to do a shout out. I saw joining us the president of the International Criminal Court. So you've got quite an audience today, Christoph. Thank you for being here.
Yes, thank you, Your Excellency. You mentioned the Yugoslavia Tribunal. Let's zoom in a bit further. The trial of President Slobodan Milosevic did not go well for the ICTY. So what went wrong, and what did the ICTY learn from that trial?
So this is an interesting thing. If you are a leader and you are accused of war crimes and crimes against humanity, and you're pretty much convinced that you're not going to be acquitted, because it's pretty tough, at that point, what are you going to do? Well, the blueprint seems to be to self-represent. Represent yourself, because that gives you all kinds of leeway that you would not afford to trial counsel. And then, once you're representing yourself, what's your goal? Your goal is to make the proceedings look unfair and to rehabilitate your legacy, your reputation among the nationalists who are your supporters at home. And so what Slobodan Milosevic did during his trial is he represented himself. And when Judge Bay, who was the first presiding judge, tried to control him, he ignored him. He made speeches when he was supposed to be asking questions, and he made personal attacks, and he used it for a lot of propaganda. And his opinion polls back home started to go up during the trial. Instead of discrediting him, he became more and more and more popular. And the people in his party started to win elections. It was having the opposite effect. So the Yugoslavia Tribunal had to wrestle with the question of, when do you put limits on self-representation? And in that case, he started to misuse his heart medication and ultimately died of heart failure, high blood pressure related illness. And the court during that time was really wrestling with, how do we keep this proceeding going when he was sick most of the time and when he was doing all these other things. So they did decide that self-representation is not an absolute right. It is a conditional right. If you abuse it, you lose it. And Over time, other tribunals, the Special Court for Sierra Leone and the Rwanda Tribunal, came up with a number of mechanisms to make sure that self-representation was not abused. One is the idea of standby counsel. And of course, Alphonse, you and Anamira were standby counsel, right? Oh, but he was. Yes, he was. So your partner was. And the idea of standby counsel is if a self-represented defendant either becomes too sick or becomes too combative and doesn't follow the proceedings, or often what happens is they go on hunger strikes or they boycott, or in the Saddam Hussein trial, they would sit in the courtroom with their back to the judges, or they would get up and yell, all kinds of things you can do to be disruptive. The standby counsel can go in and be put in place without a long recess in the trial and keep things going. And so part of the lesson is that, and then there's also lessons about having rules of the road for defense counsel. And over time, there have been more and more stronger rules for all trial prosecutors and defense counsel that have been systematically adopted by first the ad hoc tribunals and now the International Criminal Court. And I think what you see with the Yugoslavia Tribunal and the ad hocs is an evolution in international criminal procedure. It started out at Nuremberg as 4 pages long. And by the time the Yugoslavia Tribunal was created, it was about 100 pages. And now with the International Criminal Court, it's quite extensive. And you have both rules and you have a lot of case law now and precedent. And things have moved along quite a bit in terms of how does an international criminal court control proceedings when a defendant, especially a head of state on trial, is bound and determined to make things difficult.
I think the other lesson also is for prosecutors to be careful as to what they charge defendants with. So with a defendant like Milosevic, who you could have charged with a panoply of crimes, you could have charged him with so many different things. Instead of doing that, you select sort of the easiest crimes to convict, perhaps those that are the most representative of the other heinous things that the leader was involved in. But it's unnecessary to have an indictment that's hundreds and hundreds of pages long when that might result in a trial that is 10 years long and where the defendant might pass away or who knows what else might happen. And so instead of that, a more selective indictment which might be necessary, which might be sufficient to result in a conviction.
If I may continue with you, in the years since the Milosevic trial, and the ad hoc tribunals have successfully prosecuted other high-level suspects. Radovan Karadzic is an example of Ratko Mladic. Which of the several trials do you consider to be the most important?
I mean, I think it's hard to say one is more important than the other. I think they're actually equally important, and I think the three together are a particularly good example of how the Yugoslavia Tribunal was able to successfully convict the head of, the former head of state, the political leader of the Bosnian Serbs, and then the military leader of the Bosnian Serbs. And so I think each case is important in its own way, and the Karadzic and Mladic convictions, obviously, the military side, but the 2 other leaders were actually successfully convicted. Those, I think, will go a long way towards establishing this very important positive legacy of the Yugoslavia Tribunal.
And I want to add that the convictions of some of the generals are equally important and maybe more important. When you talk about deterrence, I don't think that heads of state are easily deterred. I don't think that they are generally people who have a reasonable calculation of the costs and benefits of international justice. They're kind of egomaniacs, and they feel like they can do no wrong and they'll succeed. And in part, that's how they've gotten so successful. But generals and military people tend to be much more reasonable in their calculations. And when they think there's a chance that they are going to go to prison for the decisions they make under command responsibility or for the orders that they give, they are much more inclined to speak up. And leaders can't succeed without followers. And so part of the lesson of the Yugoslavia Tribunal and the other tribunals is a lesson beamed toward the military. And it is the military convictions, I think, that have the most power in that lesson.
And actually, Chris, if I might just add, another thing that I think is important to remember here, I think one of the other reasons why the Yugoslavia Tribunal was successful in ultimately convicting the most responsible leaders was that it really started at a much lower level. So there's something to be, some people say, well, a tribunal shouldn't waste resources on the prosecution of someone who wasn't, that important. And if you think of the first defendant in the Yugoslavia Tribunal, Duško Tadić, nobody, he was not a particularly well-known figure in the former Yugoslavia. Everybody knew who Karadzic was, everybody knew who Mladic was. He wasn't particularly well-known. And yet the tribunal was able to kind of start with him and then convict some of the lower level leaders and kind of go up and up the chain of command and ultimately successfully convict Mladic and Karadzic. And some people say basically you shouldn't start at the top. That you really have to build your prosecution, start at a lower level, and then the evidence kind of starts pouring in, and that enables you to go after the actual leaders.
Thanks. We've now looked at the legal dimension. Do you think that in addition to the legal objectives that the ad hoc tribunals actually foster peace and reconciliation?
Now that's a tricky one. My origins with this topic starts in 89 to 93 when I was attorney advisor for UN Affairs at the State Department. And when the Bosnia conflict broke out, I was asked to be part of a team that, from the United States, drafted our proposed rules of procedure, our proposed provisions for the statute, and the Security Council resolutions and the explanation of vote related to creating the Yugoslavia Tribunal. And one of the things that we believed at the time was that Nuremberg had an expressivist function. In other words, it was able to document and educate the German people to the bankruptcy of the Nazi ideology by showing all the horrible things that had occurred during the trial. And that way, it discredited the Nazis and made it so that the country could move on. And therefore, it led to peace and reconciliation. That was the myth that we were taught to believe. I stuck a clause into the resolution that created the Yugoslavia Tribunal that said that part of its goal was to foster peace and reconciliation. And we believed that it would have that goal if it successfully discredited the nationalist leaders that committed atrocities. It wasn't until several years after that that the State Department declassified what had been a secret study that was conducted by the government of the United States in Germany during and after the Nuremberg trials. And the study was based on opinion polls, Gallup polls. They asked two questions. One was, do you Germans believe that Hermann Goering and the other Nazis who were convicted were actually guilty? And the second question was, do you think that the Nuremberg Tribunal was fair? And you might think that it was a close call, but it wasn't. 95% of the German people after Nuremberg thought it was unfair and that Hermann Goering was innocent. Nuremberg did not discredit the Nazis. They made Hermann Goering more popular than ever. And we should probably not be surprised that international tribunals don't create peace and reconciliation in the short run. In fact, what they do is they wedge populations apart. The perpetrators that are being prosecuted deny that they're guilty, or they use rationales that justify what they did. The victims groups get more and more angry at the perpetrators as they hear the testimony of what happened. And it just makes them very angry at each other. It's prying them apart. Now, what happened in Germany? 25 years later, there were national courts that prosecuted the concentration camp commanders in Germany. And they showed that these very heinous people that weren't sympathetic at all had done terrible things, and they were convicted and prosecuted by their own people. And that started to change the German opinions. Not only that, but the United States and the other occupying powers actually had control over the history books that were being provided to little kids and high school kids in Germany from 1946 to about 1965. And therefore, a whole generation grew up with the lessons that the victorious countries wanted them to know. And I'm not sure which of those two things had a bigger effect. It may even be Hollywood, because what a lot of people, according to opinion polls, think they know about the Holocaust. They learned in some very popular movies, Judgment at Nuremberg, and later the Holocaust TV series. And there is evidence that what you learn on TV is not exactly what happened, because it's TV. But all of those things had a bigger effect in the educated value of the initiative than the Nuremberg trial itself did. And I think the same thing is shown in the Yugoslavia Tribunal and the Rwanda Tribunal, that in the short run, these trials are not creating peace and reconciliation. In one respect, they sort of do, because they have specific deterrence. In other words, if the troublemakers, the nationalists, the politicians are not in their country, but they're in the dock in The Hague or awaiting trial in Scheveningen, they aren't able to cause trouble. So in that way, I think it has led to peace. But as an educator, the international tribunals, they do educate in the long run. And I do think the lessons of the tribunals, it takes a generation or two, but because they're so well documented, that they do take hold. But I also think the lesson of Hollywood is that in order for people to really know about what happened in the trials, there needs to be more effort to create documentaries and even Hollywood-style TV movies based on these trials, because that's really where most of the populations from all over the world learn about history. It's kind of ironic, but I think that there's something to that.
So I don't disagree at all, and I would actually mention, some of you might be familiar, our colleague Marko Milanovic, who's a professor at the University of Nottingham in the UK, relatively recently published an article in the American Journal of International Law, where he described essentially surveys that he had undertaken in the former Yugoslavia, asking people about the tribunals, asking people about the perception of the Yugoslavia Tribunal, and basically the surveys showed that no, there is no reconciliation right now. People still view the tribunal in a fairly negative light, or people view the tribunal in a negative light. Like if it's people from Serbia who are being surveyed, they perceive the tribunal negatively if the defendants are Serbian. People in Croatia perceive it negatively if the case is about a Croatian defendant. Those who were acquitted or who finished their sentences or sent back home to Croatia, Bosnia, Serbia often are received as heroes. They're not, they're received and everybody's, welcoming them with open arms. I recently was at a panel where somebody was talking, a scholar from Australia who conducted all these interviews with Milena Sterio, who was also a Serb, was one of the leaders of the Bosnian Serbs. She had served 5 or 6 years in a Swedish prison, I think. And she walks around Belgrade today, and people go up to her and kiss her hand and hug her and treat her really, really well. But I think Michael is right that it might be too early. If you think about the timing, the chronology here, the conflict was from 1991 to 1995. We now have basically a very young first generation of those who were born after the conflict. They're young adults. So I think we're asking these questions way too early. I think we should repeat the same study 20, 30 years from now.
Thank you. Milena, I often heard criticism of the ad hoc tribunals that they're very expensive. The trials, they cost millions of dollars, and in addition to that, they also take very long. So what is your view on this criticism?
I mean, yes, they are expensive, not just the ICTY or the ICTR, but all the tribunals that we have had over the last 20, 25 years. But it is really hard to put a sticker price on international criminal justice, right? I think it'd be unfair to say, if we spend 5 million, that's okay, but if we spend 10 million, that's way too much, right? So I think we can continue to talk about the efficiency of the tribunals. We can continue to work with the tribunals to encourage them to be, efficient about their work, to make good prosecutorial decisions. But I think it's incredibly important to continue to have them. And I think the question of the price to me is just not a very good question.
Of course, if you compare the price to what a peacekeeping force or what something like a Chapter 7 intervention costs when you have a conflict, it's just so tiny. One of the things that I find really interesting is a development in the International Criminal Court, where the prosecutor has started to use preliminary investigations as a way of warning a country where there's warning signs about potential genocide or crimes against humanity, that, and I'm going to make one of these, my son does this, I've got my eye on you. It's the International Criminal Court saying, we've got our eye on you. We're watching you. We might move this to a real full investigation if things don't stop. And I do think there's some anecdotal evidence that that is working, that that is scaring the leaders in the military into pulling back from the direction that they're going. And that's a really interesting new development, and I think that's positive, because that is going to save money for everybody if we do not have to intervene or we don't have to save lives because of the existence of the International Criminal Court.
Michael, you spent your sabbatical in 2008 working as a special assistant to the International Prosecutor of the Extraordinary Chambers in the courts of Cambodia, located in Phnom Penh. That tribunal was, of course, a hybrid mix of national and international judges and prosecutors. It was located also in a country where the crimes took place. So what do you think were and still are the advantages and also disadvantages of this hybrid system?
So Robert Petit, who was the chief prosecutor of the Cambodia Tribunal, wrote a chapter in my last book, The Founders, which was about the founding chief prosecutors of 5 international tribunals, in which his first sentence is, if you set out to create a tribunal whose purpose was to fail, you could not do a better job than they did when they created the Cambodia Tribunal. And this is the chief prosecutor saying that. And that's because it was really built under a challenging situation, and the political compromises were so great that it made it extremely difficult for that tribunal to succeed. On the other hand, I believe that international tribunals and international justice works best domestically where that's possible. The reason why the German courts were so successful at re-educating the German people where Nuremberg failed is because it was the German courts, the German judges trying the German people, and they trusted that they would do the right thing. And that might be the same thing with the Cambodia courts, the Gacaca courts in Rwanda. And so where it's possible to have domestic litigation, I think it is superior to international litigation. I think that the people have access to the courtroom. In Cambodia, they have had more people watch the Cambodia Tribunal's trials than any trial in history. It's got this giant courtroom, and they busload children and high school kids every day to watch the trials. And you can't do that if you have to go to The Hague for a trial. But having said that, there are a lot of times when you simply cannot have domestic justice. In Rwanda, when most of all the judges had been killed, you could not have had domestic justice. In the Charles Taylor trial, they had done the special corpus Leone cases, and then they realized that his case was just too big to have in Freetown. For security reasons, they had to move it out. And so sometimes you do need to be removed. And I think the whole idea of the International Criminal Court and complementarity is based on the view that domestic justice is best when it works, but sometimes it doesn't work, and that's when you need international justice.
Yeah, and I would just add that, I also think that domestic justice works really well, when it works well. And I would, as an example of that, I would add that, for example, the ICTY, starting in 2004, 2005, started transferring cases to the Bosnian War Crimes Chamber, which has now developed this very extensive case law, very good case law. So there's a specialized domestic chamber which is able to prosecute the cases that this international tribunal could not. And so I think that the international, with working, in tandem with the domestic jurisdiction when that was possible, because also in Bosnia, I would say that in 1995 that wasn't possible, but in 2005 that became possible.
Now we talked about the ad hoc tribunals. Let's also move now to the permanent international criminal courts. How do you think that this court compares with the ad hoc tribunals that you've addressed in your book? And as you all know, the ICC is recently going through quite a rough time with many of its decisions being criticized. For example, being the rejection to open the investigation in Afghanistan. So what's your view on this?
Yeah, I'm afraid to say anything. Both Michael and I were at the opening of the ICC Moot Court competition a couple of days ago, and Judge Kim Prost was there. And she gave a lecture. She talked about the ICC, and she used this analogy that I thought was really, really good. She said how the ICC was basically like a teenager. that it was at a moment of crises, right? And it could go in a very positive direction. Things could happen, really well, or things could happen, not so well. And I have a 15-year-old son, so this analogy really spoke to me. I said, Keith, that was really brilliant. But I think there are lots of positive and good things about the ICC. Yes, there's a little bit of a crisis now, but I think that things could still work out really well. And I think that sort of two things. One, I think we're expecting way too much out of the court because it is just one court, and it's the kind of thing where like on Monday the judges and the prosecutors and they're looking at Afghanistan, but on Tuesday they're looking at the Ivory Coast, and on Wednesday they're looking at yet a completely other country. So I think it's really much more difficult to do that rather than when you had an ad hoc tribunal that's looking at just the former Yugoslavia or just Rwanda. So I think the task itself that the court has before it is much more difficult, and it obviously has very lenient resources. And I also think that, and Judge Prof talked about it, and I think she's absolutely right, often when there's a crisis happening in the world, people think like, what is the ICC going to do about it? But people forget about complementarity. It is a court that's based on this complementarity principle where the affected state is the one that's supposed to take primary responsibility, and then only if it is unwilling and unable to do something about this, that's when the court gets involved. So I think we're asking the wrong question often. I think we should first turn to the state, and then if that state isn't able and willing to do something, or if there aren't other options, only then does the court get involved. So I think we're being way too demanding of the court.
If I want to add the story of al-Bashir of the Sudan to answer your question. So he gets indicted for genocide, and he decides to test both the ICC and the political will of the Security Council by hopscotching around the world, mostly in Africa, but also to places like Jordan and like China, and no country arrests him. Now, the president and the prosecutor give reports and send messages to the Security Council. They say, look, you referred this case to us, and now he is flouting international justice and the power of the Security Council. What are you going to do? And the Security Council writes a note back saying, so noted. Period. Full stop. It's not the International Criminal Court whose credibility in that situation was questioned. It was the Security Council itself. And that's something that I think people haven't really fully come to terms with. And it's a scary moment when our Security Council, because of the veto and because of the split between East and West that has once again come just like the worst days of the Cold War, that the Security Council seems to be unable to take any positive action even when genocide is occurring. Now, there is a potentially positive aspect to this case study, and that is that international justice is patient and persistent. And everybody always said, oh, that al-Bashir, he's going to escape justice. He's going to make the ICC look like a laughingstock. But guess what? Last month, he fell from power. Who saw that coming? And if he is surrendered to The Hague, which he could be, I think it's probably in the interest of the military government to get rid of him in a way that removes him from the scene but doesn't look vengeful, which would be sending him to The Hague, where he can have a fair trial. And I think he might think he'd get a fairer trial in The Hague than he will get in the Sudan. Some people have fared quite well at the ICC. If he goes to the ICC, it's a game changer. We're not talking about 2019 being a tough year for the ICC. We're talking about it being the most glorious year for the ICC. And that could well happen before the end of the year. So keep your seatbelts on. It's going to be an interesting ride.
Thanks. A bit of a different topic. Michael, recently the UN has established multiple investigative missions, such as the IIIM in Syria and one in Myanmar. How do you view these mechanisms in the context of the ad hoc tribunals? Are they a continuation, or are they more a bit departure?
So in a way, the ad hoc tribunals were a creature of their time. When I was at the State Department, it was a very unusual time in history. I was attorney advisor for UN Affairs, and under my watch, the Security Council passed more resolutions in 2 years than they had in the previous 50 years combined. And all these peacekeeping forces were created. There were ad hoc tribunals created. There were no-fly zones. There were sanctions regimes. I mean, the UN was doing what it was designed to do, and it lasted for about 2 years. And now the UN is completely paralyzed. And the fact that in Syria, you could have a government using chemical weapons against its own people repeatedly, well documented, and you have a permanent member of the Security Council that not once but 12 times vetoes resolutions to condemn that action, to investigate that action, to have a commission of experts designed to look into that action. That has created, for every action in international law, there's an equal and opposite reaction. It's like the physics of international diplomacy. And that's created a power shift. So the UN General Assembly decided to create its own investigative mechanism, the IIIM. And Russia says, you can't do that, only the Security Council can do that. But guess what? Russia, you can't say that because you're using the veto in a way that the rest of the world thinks is abusive and wrong. And so the rest of the world backed it. And now you have a GA-created mechanism that nobody thought could ever happen. And the same thing has happened with Burma. For the same reasons, now you have a IIIM for Burma. And so I think what you're seeing is the Security Council's paralysis. It means you're not going to see ad hoc tribunals created by the Security Council in the future, which is unfortunate because they were very efficient and they had a lot of good precedents. They accomplished a lot of good things. But you're seeing that because of that paralysis, the world is finding another way to keep international accountability moving forward. And these mechanisms, when they come out with their final reports, it is going to create a lot of political pressure to have the next step, which could be regional tribunals, it could be referral to the ICC, it could be new kinds of mechanisms that we haven't even imagined yet. But we are past the days of impunity. We are at an era where the international community has embraced accountability, and even though the Security Council is paralyzed, the rest of the world keeps finding a way.
And I would just briefly add that the reality is that the best approaches to transitional justice are to essentially use all sorts of different options, right? Not to say like the ICC is the answer to everything or ad hoc tribunals are the answer to everything. That's not really the case. The reality is that the ICC can only prosecute when it has jurisdiction, that ad hoc tribunals can only be created if there's Security Council backing or if there's agreement by the host country, and the host country really will only agree if the offending regime is no longer in power. No regime is going to agree to have itself investigated, right? So there are situations where there's no Security Council backing, the ICC doesn't have jurisdiction, the host country is still ruled by the regime that committed the atrocities, and so then options like the IIIM are the only way forward for now. And as Michael said, it is absolutely correct that hopefully the findings of these investigative bodies will someday be used in a tribunal. It could be domestic prosecutions, it could be some future international tribunals, but those findings, those reports are going to be around forever. They're not going to disappear. And so I think the investigative mechanisms play a really important role in these situations where no other option is possible.
Thanks. Now we already touched upon this very briefly, especially in the context of the ICY. Now in any discussion on international criminal justice, the peace versus justice topic comes up. What is your view on this?
So I think,
thoughts.
Yeah, so sure. So I think the question sometimes is asked like peace versus justice, but I think the right question is more about sequencing peace and justice. I think peace and justice are both equally important, and I think it's just important to sequence them in the correct order. And I think this is very context specific. In some examples, I think for example about South Africa, when the apartheid regime, when they stepped out of power, one of the sort of conditions, the only way they were going to peacefully step out of power was if there was a TRC and not prosecutions, right? So that was the correct approach there. That might not be true in every single context. So I think the better question to ask is how to sequence peace and justice, whether to have peace first and then justice later, or justice and then peace, or both at the same time. But I think this is a very context-specific inquiry.